Good afternoon, everybody. Welcome back from our lunch session. And today we are very excited to have two of our law school deans here, Dean Lawson and Dean Verona. As well, we have Law Clerk Board Chair Emily Rose. So, again, it's always great to check in with all of you, and we're looking forward to a productive discussion this afternoon.
So, this isn't particularly formal, but often we start by inviting our panelists to give us some initial remarks, maybe anything interesting about the entering class, anything you think the bar should know about our future members. So, Dean Lawson, would you like to start?
Thank you. It goes without saying, but I will just start by saying thank you. And it's a pleasure to be here and be invited and have this opportunity for broader discussion. And even as they were setting up, they removed the presenters tab and they said, because we are joining this discussion and joining this meeting. So I appreciate that warm welcome and that invitation to share, some of the things that from the decanal side of the house of our beautiful profession that we are working on and thinking of. At the University of Washington, we are celebrating 125 years of our law school this year. So I know I have some graduates in the room. So I want to congratulate the Law Dogs. And you'll be hearing more about celebrations that we are having. We have a gala planned in April. We last week had a reunion event where we were also celebrating our graduates at 55 years, 50 years, 40 years, 30 years, 20 years, and 10 years. So milestones and celebration and the impact of our graduates. It's even more special that it's the 125th year this year that we received an impactful, transformative gift from one of our graduates, Stan Bear and his wife Alta Bear, class of 63, donated to the law school $45 million. And I know we all have views about rankings, and I think you all know my views about rankings, but I just want to share with you how that level of commitment ranks nationally for law schools in the top 6. So universities often get that level of funding, but not law schools often. And so we are humbled and inspired by the commitment that Stan and Alta Bear gave to the School of Law. And I see it as their belief in the future of our profession and of our law graduates in particular. So we are working to make that really impactful and meaningful for the next group of students. We intend to have more scholarships, a few more faculty, and other things. So the focus is in leadership in law and global development. That was the vision of Stan and the work that he had been already doing with our students and our fellows. So we will be amplifying that. So you'll learn more about that as we roll it out. But it's a very meaningful, endowed program now. Some other highlights. We have a new veterans clinic. You might have seen that across the internet. I think it was announced in September. So this will provide free legal services starting next year for veterans' rights. So we are excited about this because not only does it help the community, which we are trying to always focus on that, but it's also going to train more lawyers in the expertise of veterans' rights. So stay tuned for that. And it's also a partnership. It's not just the University of Washington acting by itself, it's in partnership with King County. So that's another important component of that work. We also have a new program. We're calling it for now Law Dogs Pathways. And this is unique to the University of Washington. It's based on a variance that was granted by the ABA, allowing us to recruit future law students from within the University of Washington without an LSAT score. As you know, the ABA has been in conversation around whether the LSAT should remain a requirement in the admissions process. Currently, Standard 503 requires a reliable, um, a relevant and reliable entrance exam. And the LSAT is that main test at the moment. There's been some experimentation and innovation around alternative methods, and we are proud to be part of the data gathering around that. So it's a 5-year pilot. We will be reporting annually to the ABA regarding the performance of the students admitted through this pathway. But I can tell you from the ground, students are very excited. The pre-law associations at the university level, undergraduate level, are very excited to engage with the law school in this way. Our Tacoma campus also already had a very robust pre-law program, and those students are very excited as well. Applications are up nationwide, and I'm sure my dean colleagues will talk about this. And applications are up about 50% at the University of Washington. From the brief update I got from our new dean of admissions, we might see some disparity in urban selection versus rural selection, and that might also be a trend nationwide. So I'll be asking my fellow deans from other states if they're seeing that kind of trend. I want to highlight that the focus right now for us is this 365-degree support of all law students. And as the applications go up, we also see an increase in first-gen students. And so what that means, I think, for all of us at this school level, but also in the profession, that we're going to need more support and more training and more mentorship of our law students and new lawyers moving forward. Some of the things that we're doing, we have, of course, an academic success and bar success team, and we are supporting that team not only with the traditional things you might imagine, but we started 2 years ago giving bar study awards, financial support to students with the most need. And we've been funding those from philanthropic contributions of our graduates. And at the same meeting, and I want to emphasize this, at the same meeting that I'm celebrating, Stan and Alta Bear and their $45 million commitment, I want to highlight another important graduate. The estate of Keith Baldwin. He, in his estate planning, he had one specific bequest, $10,000 to the University of Washington School of Law. So I want to emphasize the impact that this makes to us, because not everyone has 45 million, but many might have 10,000, and that with that 10,000, even though it seems small, we are able to fund probably 4 of these students for their study in the summer, and we're building that fund more and more, and we want to have more robust support for students during their bar prep, because we know that's a hurdle, and sometimes the financial hurdle is the hurdle that creates the disparity in moving forward. And I just close with saying that we're excited to be participating in the task force. I think our first meeting is next week, where we'll be looking at the implementation phase of the Washington Supreme Court's opportunity to have alternative pathways to licensure. I think even the Veterans Clinic speaks to the opportunities that students will have to use their skills from an experiential courses to lead them into the profession. Many students will tell you, many graduates will tell you the most impactful time they had in law school was in a clinical or experiential learning experience. So we're excited to partner with this body and the Supreme Court on that.
Thank you so much, Dean Lawson. And I note that Dean Rooksby has joined us, so welcome. Um, uh, Perhaps should I turn it over next to Dean Verona?
Thank you. Well, thank you, everyone. I join Dean Lawson in thanking all of you for inviting us to join you. And I congratulate you for all of the work that you've been able to get done, and that you have been working together so cohesively and so well. We are doing well at Seattle University School of Law. We brought in the strongest class academically this year in 15 years, and it also happens to be one of the most diverse entering classes in our history, with the largest cohort of first-generation students and the largest cohort of veteran students. We're very excited about what has been happening with our Bar Success program. We're up by, I think, 6 points over last year. We're also greatly improving our employment statistics. We've gotten some national recognition there too. We have launched a couple of new clinics. One of them, so going along with what Dean Lawson said, we too have been evolving our clinics to be more responsive to community needs. And so one of them is a new and very innovative digital lawyering clinic that's focusing on cybercrime. And we're in partnership with a very prominent law firm in that clinic. We're also in early discussion, and I hope, and I'm very hopeful that these discussions will come to a very positive conclusion, to launch a new farm workers' rights clinic from our Central Washington hybrid hub, which is something that is very much needed. I was in conversation with U.S. Attorney Waldreff about how the U.S. Attorney's Office can be helpful, and obviously a lot of our stakeholder communities and leaders in Central Washington have been very encouraging of us, of this particular initiative. We are thrilled to have launched all 3 hybrid hubs that I briefed you about last year. So all 3 have been launched. Again, this was an initiative that we launched in my first year as dean, after I kept hearing from stakeholders and leaders in law throughout the state and throughout the region, really, about the problem of legal deserts, where there was a very alarming shortage of lawyers, no physical law school presence, and a burgeoning community of prospective law students who were land-bound, family-bound, work-bound, and could not move to Spokane or to Seattle to come to one of our brick-and-mortar law schools. So I started discussion with a number of institutions in those 3 major legal deserts, so Central Washington in the Yakima Valley, the South Sound, and in Alaska. And we have signed partnerships now with 5 institutions to launch the 3 hybrid hubs. And we've had launch events. They were very positively covered by the regional and national media. And so I don't want to cover information that I'm sure you have read about already, but I will say that we're very, very happy with the response that we have received so far. These hybrid hubs not only are responsive to the legal desert issue, but also they are providing access to legal education to very promising students who otherwise don't have access. And so the demand that we have already seen is extraordinary. And most of the students that are articulating interest in our hybrid hubs and the Flex JD program that is present at each of those hubs, it's just extraordinary. Most of them are first-generation students, most of them Native students, students of color. So we're very excited. We also have been hiring faculty at each of those hybrid hub locations, including Central Washington, South Sound, and in Alaska. The adjunct professor that we just appointed to teach constitutional law from the hybrid hub in Alaska is a former Justice Sotomayor clerk. and a recent editor-in-chief of the UCLA Law Review. Bree Blackhorse, the assistant U.S. attorney in the Central Washington region, is our hub director for Central Washington. And I can go on and on. So we're very excited about this initiative. It has with it 3+3.5 programs, accelerated standing programs, special scholarships for these students, special networking, special pipeline programming for high school and college age students in each of those hubs, adjunct taught courses, and lots of resources with the local brick and mortar institution to allow these students to have physical study spaces, access to gyms, etc., so that we are replicating a lot of the intellectual life, a lot of the physical resources that otherwise would be provided by a brick and mortar law school. And so the three hubs are Alaska, Central Washington, South Sound. The partners are, the principal founding partners are the University of Washington Tacoma for the South Sound hub, also University of Puget Sound. So in a way, we are going back home to our roots. Heritage U in the Yakima Valley, and the University of Alaska Anchorage and Alaska Pacific in Anchorage. Very exciting initiative. I will also tell you that the Flex JD program is surprising us with just how successful it has been. We had very high hopes for it, but it has turned out to be our marquee program. We are achieving academic credentials for entering 1L students in that program that are now exceeding the daytime program. And a lot of it has to do with how we are providing access to these students who otherwise wouldn't have access. So one student that I will describe for you, who is one of our brand new Flex JD students, is a lead captain for a major airline, next to whom I was sitting on a flight from Washington, D.C. to Seattle about a year ago. And we took off, and there was something wrong with the seat in front, and he got up and fixed the seat, and he got back down, and I said, wow, you must know a lot about planes. And he told me that he was a lead captain for the airline flying deadhead to Seattle. And he asked me what I did, and one thing led to another. And he said he'd always wanted to be a lawyer, but loved his current job. But he always had these aspirations of being one of these associate general counsel for the airline who happened to fly as a pilot, but also serve as a lawyer. And one thing led to another. I asked him whether he knew about our Flex JD program, and he, a U.S. Air Force veteran with wonderful academic credentials from the past and this incredible professional experience, is now one of our students. So it just goes to show that we have leveraged new technology in order to expand access to high quality legal ed, not just in Seattle, but also in these hybrid hubs. A couple of other things that I'll brief you on that might be notable is that we are in discussion with AccessLex about a very significant partnership that I'm very excited to share with you the details of soon, but it's still cooking. And we are excited about some new faculty hires that we have made and that we continue to cultivate over these weeks. And so we'll be making some announcements soon about that. My fellow deans and I took part this week in a very important gathering here in Seattle of the ABA Council on Legal Ed and Admission to the Bar. This was a particularly important gathering given what happened with the election results. And so there are some questions that the council will be having to address over the next year or so. There are questions about accreditation standards, accreditation at all, what the Department of Education might be doing or not doing. And so it's very important for us to, as a state bar association, as a profession, to be vigilant, to be in conversation, and to be responsive to the needs of our broader community, of our students, of our graduates, but also in conversation with our accrediting bodies. And so that's why it was very important for my fellow deans and I to be very present over the last few days. And Jacob was present in person here with the council. So very important conversations, and we will continue to be in conversation with those colleagues. So I will just leave it there.
Thank you so much. Dean Rooksby.
Thank you. Hello. Oh, it's good to see the room. Okay, now I can get a sense of the environment there. Sorry, I can't be with you in person. As Dean Verona mentioned, I was recently, though, in Seattle for the ABA Council gathering, and we'll be heading back next week for the Alternative Pathways to Licensure kickoff meeting that was referenced by Dean Lawson. So exciting things going on here at Gonzaga Law School. We welcomed another strong entering class of 191 students this past fall. It was our most diverse class ever at 28.5%. Just to put that in perspective, when I started in 2018 and first met with this group, I think at Gonzaga Law School, the diversity of our entering class was 12%. So we've made significant improvements and headway there. We are also a school that has right now a very new faculty. Over 60% of our full-time faculty have been hired in the last 7 years. So we've seen just some natural transitions and retirements that have enabled hiring opportunities. With that, great excitement and energy from new faculty joining us from all over the country and the world, really. We engaged in a curricular reform process over the past 2 academic years that resulted in a new academic calendar that was implemented this year for the first time. This calendar, we've moved from a 15-week semester to a 13-week semester, but at the beginning of each semester, we have a 1-week intersession. So that's offered in August and also in January at no extra cost to our students. They can enroll in a 1-credit course, or they can do other enriching opportunities that we offer that are non-credit bearing. This gives us, I think, some flexibility that we did not have before to offer niche courses, also to bring in adjunct faculty who may not be available to teach for an entire semester, but could give us 2 hours a day for 5 days in one of our intersessions. It's also provided a chance for some international programming that we're excited about. In January, one of our professors is taking a group of students to Guatemala and Belize to learn about law and justice in Central America. And so it's something that we're starting to kind of really kick the tires on and figure out all the different ways that we can use this new intersession opportunity to benefit students. We also have implemented a new required 1L course on lawyering skills, focusing on many of the actual practical aspects of practicing law, and that's right in our 1L curriculum. So we are, we've brought in adjunct faculty, but also we have several of our full-time faculty who are leading that effort and creating the curriculum. Another thing that I'll mention, and I'm in year 7 now of this deanship at Gonzaga. It's been a great ride. And many of you may remember in years past, we were launching new things at the law school. We've kind of hit a point, I think, of saturation on new things during my time. But one that we inaugurated several years ago now, which we're very proud of, is our LGBTQ rights clinic. And we'll soon be issuing a press release about a really marquee case that our clinic resolved favorably for a client, resulting in a 6-figure settlement, which is the largest settlement that any of our clinics have ever been able to garner for a client. So very exciting story coming on that front. And we have continued to really lean into the clinical space. Obviously, this is both an ABA requirement, but also I just think a really exciting part of legal education is what we can do in our clinics. I'll stop there and look forward to any questions or dialogue that may be forthcoming.
Thank you, Dean. And I wonder, Chair Rose, if you would like to let us know what's happening on the law clerk side.
Hello, Bog friends. Can you hear me? Okay, I'm going to assume that someone
Yes.
can. Excellent, thank you. Hi, I'm Emily Rose. I am the current chair of the law clerk program. In addition to being an alumna of the program, I was a paralegal who became an attorney without going to a JD program. So I've been involved with this program since 2008 is when I started the program, and I've been on the board for a real long time, and I'm a huge advocate. So thank you for hearing from us at this meeting. As far as what's been going on with us, we are an alternative to law school that's authorized under Rule 6 of the Washington State Admission and Practice Rules. And so it is a apprenticeship-based program, kind of like the way that people always used to become attorneys before JD programs existed, Bob Cratchit style, if you will. And we are proud to serve Washington State, especially in terms of providing access to legal education for folks who may be underserved. Some of my dean colleagues earlier who were presenting were talking about the really innovative things that they've been doing with their schools to reach out to folks that might otherwise not have an opportunity to attend a JD program. And I am in love with all of those innovations. And the Clerk program, I would say, in its very basis, is all about that. We have a lot of enrollees who are people who would not otherwise be able to be in a JD program, either because they are single parents or because they do not live near an existing JD program or because they work full time. In fact, one of the sort of hallmarks of the program is that you are required to work full time in a paralegal capacity while you are getting your legal education. That's kind of our thing. So we think that we address both being able to provide access to legal education to underserved communities and legal deserts, as well as providing access to folks that perhaps don't have the financial means to attend a JD program, and to provide legal services and legal professionals to areas that are lacking those things. So I'm really excited about APR 6's ability to help with those things. The Clerk program has also been steadily increasing in numbers over the years. At this time, there's about 115 law clerks enrolled in the Law Clerk program statewide, and that is up from about 75 just 10 years ago. So that's quite a substantial growth in the program that we're excited about. And folks can join the Clerk program all year round. We have rolling admissions, if you will. So any time of year that someone is eligible and interested, they can submit an application for consideration and approval by the board. So we're still accepting applications as we speak. Tell your friends. We have had a steady increase in applications as well over the last 4 years. It looks like from 2021, we had about 38 applications that year. And this year, so far, we've received 49 applications. So we're also really excited about just the growth in interest in the program. And our board and our committee have committed time to creating opportunities for expansion and awareness of the Clerk program, since as a legal education program, we're certainly the smallest program in Washington and perhaps the least well-known, although we're doing everything we can to change that. And so we have a program expansion committee, and we have been working hard to engage in conversations with groups that might be interested in sending clerks to the program, and in sort of brainstorming other ways in which the program could be expanded. We've been having conversations with leaders in the various diversity bar programs that there are, and folks that serve minority communities in particular, because that is an aligned partnership where our interests are very much shared, and that has been a productive conversation. And we also take the opportunity to reach out to local bar associations and paralegal programs to share information about the Clerk program, to help folks that might be a good fit to learn about the program and encourage them to get involved. It looks like at this time, the stats would indicate that about 30% of our currently enrolled clerks are working in what we would call rural and underserved communities in Washington. And those are places that are away from the law school campuses. So they are actively working in those legal deserts, which is pretty exciting news. And at this time, according to our stats, about 23% of the folks who've completed the law clerk program and become attorneys are now practicing in rural communities that are distant from the urban areas and from traditional law school programs. So we think that that's exciting news as well. I think we often hear from folks who are enrolling or who are in the clerk program that one of the things that drew them to that program is that they don't feel like a traditional JD program might be accessible to them in their area where their family and their community are. So we get to come to them, so to speak, which is really very neat. We have goals for our coming years to continue to do outreach efforts to share information about the program, both so that members of the legal community, like WSBA members, are just aware of it. And if they see someone who might be a good fit for the program, that they share that information. Because I think something we hear a lot is we didn't even know that the clerk program existed. We didn't know that this was an option. And frankly, Kim Kardashian has helped our PR a lot because she engaged in a program that's somewhat like APR 6 in California. And a lot of people heard about clerking from her. But we can use all of the awareness and all of the PR that we can get. So we're always trying to just spread the word about the program and participation in that program. We are also actively working with WSBA to ensure parity with law clerks to other law school students and inclusion of our students. We are always advocating for law clerks to be offered the same benefits as law students with various organizations like student CLE tuition discounts and bar prep course offerings. WSBA does offer the same CLE rate to law clerks and law students for their CLEs. And then we advocate actively so that legal employers that might otherwise be inclined to say that their posting requires a JD might include that the APR 6 program and passing the bar might be an alternative, since it is for a lot of places in Washington. Okay, I think that that's most of what I wanted to share with you. Another fun fact that I learned recently is that since 1984, which is when the modern day clerk program was started, 77% of the law clerks who completed the program overall have passed the bar exam. Thank you for letting us be here today.
Thank you so much, Teros, and thank you, Deans. And at this time, I invite people to, if you have any questions or comments for the Deans, if I could actually jump ahead of the queue, I have a question for all of you. The Diversity, Equity, and Inclusion Council has we're in the process of rolling out a DEI plan, a strategic plan called the Equity and Justice Plan. It's based on a demographic study that was done. And Chief Diana Singleton over there will be able to correct me if I'm getting it wrong, but I do believe that we have circulated the draft of the plan and we are planning to send it out to all of you. So I'm just putting in a little plug and a pitch for having someone from, your entity read the plan. I would love it if all of you would individually read it. It's short, but we need feedback on this. So that's my pitch. I don't know if Chief Singleton wants to say anything else about it, but
I don't know, just to confirm that hopefully you did get it via email to all of the deans and all of the chairs of all the entities, including the law clerk board. And then we also have DI council members who have been doing their own outreach to the student organizations as well, particularly the affinity student organizations to get their input as well.
And one other last thing, the DEI Council made space for there to be law school representatives on the council. And I think the council would love to see representatives from all three law schools. It'd be great to have a law clerk representative too. Certainly our charter would allow it. So please stay tuned on that. I think we're going to be more in touch with you folks to kind of try to set that up in the coming, but it would be very exciting if we could have a rep from each law school on the council
Well,
and the board.
I will accept that invitation on behalf of the University of Washington School of Law, and also just highlight that part of the discussions that we are having with the ABA Council on Legal Education, who are in Seattle this week, is around this particular issue as well. There is a standard within the accreditation standards, ABA Standard 206, currently entitled Diversity and Inclusion, but has been proposed to be changed to access to legal education and the profession. And we just received within the, I think, the span of this meeting, the updated proposed new version. So we're on the third version of this proposed amended accreditation standard. So
Wonderful. That's
thank
great.
you.
Look forward to that. Governor Ahern, did you have a question? Or did you not? And
I
just-
hadn't raised my hand.
Oh, I thought I saw
But you're good at reading the tea leaves. Yes, I do. Actually, I have two types of questions. I'll ask one, and then everybody else can ask their questions, and I'll ask my other. But the big question is, well, at least for me, access to a legal education depends on money. And I know from just the associates that work at my firm how hopelessly in debt they are. And I'm thinking, okay, there's no freaking way that I would have been able to ever go to law school if costs back in the Stone Age when I went are what they are now. So here's my question. How much at each of your three schools, if I, no student aid, no nothing, if I'm just going from the beginning, first day of class to the end, how much in debt am I going to be? How much am I going to pay? And there are two components, the tuition and the stuff that you guys charge. But then there's also just the cost of living and things like that in your area. And I know you can't give me precise numbers, but just ballpark. So frankly, I want to know whether these horror stories I'm hearing are close to reality.
I have
This question because
just
oh, I'm so sorry. I thank you very much for asking this question, because it is one that we struggle with every day at Seattle University School of Law, since we are doing so much with respect to access to legal ed. One of the things that we have found is that although we are providing these hybrid hubs and attracting and identifying talent among a lot of these prospective students in Central Washington and in Alaska, in the South Sound, and in the greater Seattle area too, we are still finding that despite the fact that it is less expensive to come to Seattle U Law through the Flex JAD program in one of those hybrid hubs because of the cost of living being lower. So the exact answer to your question is it depends on where you are, how you are studying in our respective programs. And it could go from 0 to 50, 60,000, depending on which program and how and where you stand and how much aid you receive. So there is no precise answer that I could give you with respect to numbers, but what I would encourage us to do, and what I would ask us to do, is to find ways to work with the state legislature, particularly in additional debt relief programming, tuition remission programs, and direct state subsidies for these students who are particularly helping solve these legal desert problems. And especially when Chief Justice Gonzalez has been telling us that, and so many others of you have been saying, that we are reaching a constitutional crisis level with respect to this legal desert problem, where it's not just a shortage, there are no defense attorneys available in certain parts of this state. So because we are reaching constitutional crisis levels, I think the state legislature and the governor have to step up and work with us in providing direct tuition subsidies for students in all 4 of our programs who are able to solve that problem, working with us and able to solve that and being able to solve that problem.
With all due respect, and since I'm a litigator, I am really, really holding back the motion to strike failure to answer the question. So just, could you give me, and I know there's not a precise answer, but ballpark, if a kid and okay, I'm old, anyone under 30 is a kid. If a kid wants to go to law school, how much is he looking at spending that 3 years in your place?
So the students are not lying to you about if they're telling you it's 200,000 and these kind of numbers. That is reasonable if they did not get a scholarship. And that's why it definitely does depend. And a lot of scholarships are based on LSAT score. And that is a criticism, I think, of our industry, because the scholarship doesn't always track the student that has the most actual need. So the data shows that 80% of all scholarship awards in law school are given without having to share even your financial need. And I think that was one of the main pushes why many law deans stepped away from the U.S. News methodology, frankly, because it was encouraging a process of buying LSAT scores and not really following the true financial need of the prospective law student. And, the dean of Yale and I wrote an article about this. It was in the Chronicle of Higher Education last year. So we're also trying to focus the resources that students do receive towards not only financial need, but also specialization in areas that will support the community. So for example, our Gates scholars are focused on public interest law as part of their, once they graduate. So the full ride scholarship helps the community. And as we start implementing the Bear Institute, we will be focused on students who want to impact global development and different ways like this. So I think it's incumbent upon each school, and Dean Verona is doing something similar at his school in a different way, and probably Dean Rooksby also in Gonzaga, but identifying students that are overcoming the true burden of the cost as opposed to scoring in a certain way on an entrance exam that doesn't prove to anyone that there's going to be a commitment to the community.
Thank you. Gonzaga? Well, could I
Hi.
have one more answer then please?
Yeah. Quality experiences cost money, and we're doing our best to provide scholarships, as my colleagues have mentioned, but we employ 30 people with JDs, and we're a small school. They expect to be paid salaries that are commensurate with their talents and experience. So I wouldn't be turned off by the sticker price at most law schools. You can see through the ABA disclosures what kinds of aid awards people are receiving on average. So I would recommend taking a look at our websites. The ABA requires a lot of disclosures of law schools that provide much of the information you seem to be seeking.
Okay. Sorry, Kevin.
Oh, hang on. I believe that
One's on.
Governor Wynn is next and then Governor Fay. Yeah, if it's a follow-up question, go ahead.
Understanding is you have to post on how much it costs a year to go to your school. I mean, because there's a cap of what people can pull off at 529. It's a set number. What is that number?
Our tuition for in-state is $44,000 a year and $55,000 a year for out-of-state, and then that would be the basis.
Mm-hmm.
57,000 is our base tuition amount. But again, if you look at that number in isolation without looking at scholarships, discount rates, special grants, you aren't really getting the overall picture. And you also have to look at the total cost of attendance depending on the individual student. So are they in Seattle? Or...
You need to publish what the total cost is at the rack rate.
Well, it's in the, I don't know if you've seen the actual ABA disclosure documents, but there are a lot of disclosures on that form, like Jacob said.
So, no, that's fine. That's fine. Are we looking for the Dean Rooksby? Okay. Dean Rooksby, we were asking the same question. I think Governor Ahern wanted to know the same question about the price cost.
Yes, and I would refer the governor to our ABA disclosures on our website.
Next, we have Governor Wynn.
If anyone else has a question related to the law school fees and tuition, I'll defer to them.
I think you're it.
Well, Mary doesn't.
I was just gonna say I won't be offended by Governor Ahern not asking how much the tuition is for the law clerk program. I believe it's currently at $5,000 a year.
2,000 a year. Okay.
Yeah, it's
Governor
substantially less
Wynn.
than five. We were the cheapest option by far, 2,000 a year, y'all.
There you go.
Um,
All right, we're going to get back to the queue now. Governor Wynn.
So this question is for Dean Larson, and it's a fun question because for this meeting, I was researching mission statement for the various law school, and I actually couldn't find the University of Washington on the website. I found it on the Law School Admission Council. Is there a mission statement?
Yes, our mission is to be the best law school measured by global impact.
Okay.
And so this gift that I was referring to is at the heart of our mission
Okay.
because it's for law and leadership and global development.
Okay. Well, I do have something to say. I wasn't clear on the website. That's one thing, and I do think a mission statement does ground organization over time, and I would. Looking at Seattle U and Gonzaga, they have a much more robust and longer mission statement that has things to do related to public service and justice. And I think the UW mission statement should have that, but also as the only public university here, there should be something about serving the well-being of Washingtonian and I'm saying this for one reason, because I have a degree from the University of Michigan. Go Blue. It has the reputation of being a very great university. It also has the reputation of having one of the strongest alumni network. And the reason for that is that it also has the reputation of everybody graduating from Michigan, most people graduating from Michigan, leaving the state. So it doesn't really serve the state well on having such a great university. And I think the University of Washington should have in this mission statement, along with the University of Michigan, actually, my alumni, that one of our mission as a public university is to serve the well-being of our citizens. That's just a comment. Thank you.
Next, we have Governor Couch.
Well, I think I feel like
absolutely.
I have to defend the University of
Absolutely,
Washington
Dean
School of
Lawson.
Law based on that comment. We have a very strong commitment at our university and our School of Law in particular on public service. And the Gates family in particular donated significant resources for us to have the Gates Scholars Program focused on public interest. And not only does it provide every year 5 full ride scholarships, but it also provides staffing that infuses our entire law school with information, weekly sessions on public interest opportunities. So all of our graduates have that. And I will talk to marketing and communications, but I know these things are on our website as well. And these are the values of our school regarding justice, also cultural competency and serving the community are infused in our students and our graduates. And I think the data bears that out.
Oh, I was not a criticism of what the program the University of Washington offer. I just think if there's a sense in the mission statement that this is what we do, I think it would ensure that future generation, future dean sees the mission of the school. It's not a criticism of what University of Washington is doing. The University of Washington overall and the law school is an economic driver for the state, more so than other universities. I just don't want what's happening with Michigan happening here. I don't want that to be Washington. I think the mission statement ensures that the future of what the university does.
Governor Couch, then Governor Petrosic, then Governor Rathbone.
My
Governor Bloom.
perennial question about, how we can help you on debt seems to have been answered already, which is great. But I do want to drill a little specific on this is what is being done to try to assess just the rising cost of law school? And I'll give an example for someone as probably one of the people who has the most recent debt. I had a full ride scholarship through law school, but I still had to live for 3 years. I was able to keep my student debt at $80,000, but I had to live and really not work because law schools and the ABA still discourage working while you're in law school. So I did pretty well, actually, compared to most of my colleagues. So are there steps being taken? I think I heard a couple hints of that in your opening about but to just reduce the cost of the education you're providing, because those costs are going up and are really high. And I noticed there was the ABA was considering changing standards 102 and 306 around and 701 around the physical space requirements. That is a huge cost absorber, around allowing more online legal education, which really drastically can decrease the cost of schools. And I was surprised to see that there was one letter with a lot of signatories from different law schools, but not a single Washington law school was on that letter or provided comments on those standard changes at all. So where are we on that?
Well, I will share with you that you have listed some of the things that we are doing. Fundraising is very important too. Raising money for student scholarships is absolutely key. If you Google Seattle University School of Law cost of attendance, you will find what we have published to our website, to go back to one of the earlier questions, for very specific numbers about what it costs to attend Seattle U Law. And not just in terms of base tuition, which this year specifically for fall spring is $58,890. But we also list the fees and cost of attendance overall. So books, room, board, personal transportation, loan fee, etc. All of the things that go into true cost. And the overall figure for fall, spring, and summer is $102,976. Does that reflect what this is what we were going back to earlier. Does that reflect what every single student pays? No, because every student is different. Every student has a different aid package. Every student might have a different scholarship level. So much of our cost of attendance varies from school to school. And our average discount rate can be anything from 30 to 45%, depending on school, right? So we try to disclose as much as we can in general terms, but it's very hard to generalize when every student is essentially paying a different amount. But Jordan gets directly into what at each of our schools we are trying to do with respect to economy. So where we can, we hire an adjunct professor instead of a visitor. We hire an adjunct professor instead of a tenure line professor. But as Dean Rooksby said, we need our law schools, the 3 law schools in Washington, to be of the highest quality possible. And that requires hiring as many tenure line professors as we possibly can, or quasi-tenure long-term contract professors as much as in as many cases as we possibly can, because they are the ones who are present. They are the ones who work directly with students. They are the ones that have time and resources to spend with our students that otherwise they would not be able to spend if they had a full-time job outside of the law school and were essentially adjuncts. So there are many examples, I would imagine, that each of us can point to at each of our schools that show that we are trying our best to economize where possible. But it's an expensive endeavor. And each and every one of us who holds a bar license and who is a graduate of a law school has a responsibility to give back and to pull others up who are climbing on that ladder behind us, by supporting our schools and other schools, and working in partnership with all of you and finding additional subsidies, whether it's from the state legislature or corporations or private public enterprises that could support legal education.
Thank you, Dean Verona.
I would add, I relate to your question and the issues you're raising with that question. Some of the costs that we can directly impact, I would just say, like books, for example. Law books are very expensive, but there is pretty much a movement right now to utilize free source materials and free source books. So that's one way law faculty and law schools can really encourage and impact the bottom line costs for students and make things more accessible and inclusive for everyone in the classroom. But I would echo the comments of Dean Verona as it relates to and Dean Rooksby around the quality of the legal education, because yes, you can, I think in some schools have, not in Washington, but other places in the country, focused on only having what we would call adjunct or part-time faculty or hybrid type faculty. But what you lose in that model is your teacher scholar who is immersed not only in the immediate course material, but in the subject matter more broadly and pursuing policy and innovation in that area of law as a full-time endeavor. So I think that is one of the tensions. Additionally, the future of legal education is in an interdisciplinary model. So we have several interdisciplinary centers at our law school. We have the Tech Policy Lab. We have the Center for the Informed Public. These centers partner not only with law faculty, but with faculty from engineering and computer science and other things. We're launching a health law center that will lean into the interdisciplinary work of medicine and public health. We have other centers of excellence, the Native American Law Center, Asian Law Center, Global Business Institute. So these types of interdisciplinary collaborations from a research one type of institution require some of the funds that make education expensive.
Yeah, and please let me add one additional footnote to what Dean Lawson said. It's expensive nowadays, more so than ever, to run a law school. From keeping the lights on to debt financing to at each and every one of our law schools, we are finding unprecedented levels of disability accommodation requests on the part of our students. Many disability accommodations are expensive to put into place, and we owe them to our students because we care about inclusion and equity, right? And so on so many levels, it's a very difficult balance to achieve, but I congratulate you and celebrate you and join you in being concerned about the cost of attendance of law school, which is we all share that same concern, and we are doing all we can to address it thoughtfully.
Governor Petrosic.
Good afternoon to everyone. This question is for everyone, including Chair Rose. I believe, Dean Verona, you mentioned at the outset in your opening comments, the need to infiltrate attorneys into rural areas. I believe all of you know that I chair the STAR committee, WSBA STAR committee. One of the things we're looking at is how to alleviate debt or relieve debt mostly for law students who commit to practicing in rural areas, perhaps for a certain period of time. Rather than having what it currently exists of loan forgiveness, you pay your debt ahead of time, and if you practice as it stands now in a legal aid setting for 10 years, you get your debt erased essentially. Is there a way that you could see right now within your law schools and maybe even with the law clerk program that if a student entering your law school or the law clerk program said, I will commit, and they'll sign a contract saying, I will commit to working in a rural area for X amount of years, then they can go to your law school or the law clerk program for free. But then also, if they somehow default on that contract, I'll have to pay back an X amount of whatever the amount of education would cost. Is that something that you could see your school or the law clerk program doing? And if so, what would it take? Would it perhaps be some generous benefactor who you could take money from some foundation or grant or, stuff that you get from a benefactor or the law program, for instance. What would it take since that's a bar regulated entity?
May I answer? Thank you very much, Madam Governor, for that excellent question. This is a conversation that I've had with a number of leaders, both in the state and in Alaska. And my understanding is that Alaska has had such a program that was created by the state legislature and then sunsetted some years ago. And we are in conversation around perhaps restarting the program there. I think this is something that we should talk about here with our legislature and with our governor about ways that we could go beyond loan forgiveness, beyond tuition remission at the start, and towards affirmative scholarships with the commitment to stay and do in particular areas. So I think it's going to take some research into what has worked in other states, what structures have been particularly effective, what incentives have worked well, what accountability there might be for licensed lawyers that don't make good on the initial commitment. So these are all questions that are outstanding, but there are answers out there because there have been successful experiments in other states that we could certainly learn from. So maybe this is a cause for an ad hoc committee that we could launch. And to go back to something that you had said earlier too, that I think is absolutely right, it can't be just one solution. There has to be private philanthropy involved, which is why all three of us are in conversation with prospective donors to subsidize this kind of effort. I certainly am, but also state solutions, particularly in those states that are articulating a significant concern around access to justice and legal deserts.
Thank you. Next.
I would just add, I would just add to Dean Verona's answer, because I come from Nevada, and Nevada had something similar to Alaska because there was no law school in Nevada for quite some time. So it was front loaded in a similar way. But the challenge with that, even though I was coming from Nevada, I didn't apply for that particular benefit because I was concerned about the commitment of only coming back to Nevada. Now, that was a mistake on my part because I immediately came back to Nevada. I was a Clark County prosecutor for 7 years, and that would have been a lot smarter if I understood all those details, but so that's something to make sure the generation of applicant or prospective student understands that if they make a different choice, they could just pay it back or something like that. But ways to incentivize beyond just, I'm just giving that example because that wasn't enough to incentivize me. Okay, so maybe this next generation, we would need more. I think that the bar could do more around incentivizing the license. And I'm just going to put it out there, diploma privilege or waiver, temporary, presumptive licensure or something if you are going to go and serve a legal desert. And that would broaden the scope of applicants or folks maybe potentially interested or, maybe reaching into the class of third-year law students and getting them connected to a rural community before they graduate. These are, I think, additional ways beyond just the dollars and cents that might help to incentivize a broader group of people excited about this, because most students go to law school because they have a passion for service. And if we can tap into that, I think we will be further along solving this problem.
Chair Rose?
This is a great question. I love it. I think that the Clerk program has kind of a built-in mechanism for that, in that not only is one required to only pay currently $2,000 a year, so that's $8,000 all in for the entire program to get to the point where you're licensed for the whole thing. But also a component of the program is that you must be working for money at a legal institution, law firm, or for a judge. And so you're making money inherently while you're paying the lower tuition. which means that student loan debt is not really a problem for our program. But even then, I think if we did have a generous benefactor who wanted to donate to a law clerk program foundation, I like the sound of that. Thank you for that idea. Then that would be a great well of money for people who even the $2,000 a year is a burden and they have other financial commitments for the money that they're making at their law firm job. So I think that that's a wonderful idea.
Dean Rooksby.
Yeah, I think these are all good suggestions. And we had a rural access to justice summit at our law school in the spring, and I think talked about some of these things. The aspect that continues to be outside of our control is the interest level in prospective and incoming students and living and serving in these rural deserts. I think that's a sort of a problem that is a hard one to understand how to solve. We've tried to convince people of the need and the opportunity as junior lawyers going to these areas to live and work for a period of years after graduation. And we're finding that most are not interested, even ones who may come from those areas don't always want to go back. So I think that's a difficulty in this. And I worry about, front end commitments then kind of evaporating on the back end as because there's a lot of uncertainties when you start law school. You may come in with a certain interest, but you have never taken a law class, so you get redirected when you take something else that you didn't know that you were going to find interesting, and then also how well one does in law school in terms of academically, other opportunities could present themselves. So I just think that's a feature of this that's tricky. But certainly, I think we're all committed to finding creative ways to address this problem.
Thank you. Next, Governor Rathbone. Oh, no. Okay. Governor Bloom.
Yeah. Hey, thank you for presenting and making yourselves available for this discussion with the Board of Governors. It sounds like it's been really productive, certainly from our perspective, and learning some of the information you've brought with you and the points that you've made with regards to some of the questions, adding to our perspective. When I probably shortly after I was out of law school, mid to late 90s, I'd come across a publication. I think it was in I forget where it was, the National Law Journal or something to that effect, that had a study showing a very high correlation between the law school admission test and academic performance in law school. You scored high in law LSAT, you got high grades in law school. You scored mediocre or poor in the LSAT, you got mediocre to poor grades on LSAT. And so it's really important, but most incoming students don't really understand that. And so I haven't seen and haven't paid attention to academic or research on this topic to whether or not that, I know, over the last several years, certainly during COVID, the LSAT kind of fell into disfavor. There'd been, a lot of things that says, hey, LSAT's no good anymore. The SAT, the ACT, any of the academic entrance exams, which I believe or understood at least at some point that there was a high level of predictive value in these exams and subsequent performance in an academic setting, whether it was the undergraduate, graduate school, law school, et cetera, whatever. So that's kind of one of the things. If it's still a predictor of academic performance, then, why won't we use that as a signal to our institution as to, selecting meritorious students for the program that are going to do well and then, and whatnot. And it used to be, the class rank and the LSAT, schools were great, racked, and that was a signal to the public, whatever, about ranking and how schools, stacked up to each other. So, but stepping back from that, then, so I had basically kind of three areas that I was kind of interested in. the other one was mentioned by, I believe, Dean Barona, might have been discussed by Dean Rooksby or some of the others as well. But the use of adjunct and kind of the adjunct to tenure track faculty. I had come across a study, I believe it was in something from Deloitte back in, I think it was 2011 or 2012. It referenced a AAUP study, and it showed from 1970 to 2011, and it showed tenure track going down significantly from about 70% to around 40%, and adjunct going from 10% to about 40%. And so clearly, when we're talking about concern for cost of education, adjuncts are a lot cheaper than tenure track faculty. So, clearly, but to Dean Lawson, I think made a point that it's important to have tenure track faculty who are researching and publishing and breaking ground on new material and new discoveries and new contributions to the academic fields. So, clearly there's some competing interests there, and then so the thoughts on that perhaps and how they might relate to your educational programs that you currently have and offer. And then the third thing I was kind of interested in was with regards to prospectively. One of y'all referenced the alternatives pathways meeting that's coming up this next week, I believe, or something. And so then what your perception is on a short, medium, intermediate term, long term, perhaps perspective on impact on maybe not necessarily your law school, but just kind of globally on law school educations generally. I mean, if this were to take off nationally, law schools could become a thing of the past, essentially in a sense, potentially, except to the extent that, they're retained for the academic purposes of, producing new research and, informing the profession and et cetera. So, because it seems to me as though if we find a way, like, for example, Chair Rose's Rule 6, which, seems like it's starting to actually get some additional, here it's doubled, in size just within the last couple of years or whatever. If this really gains traction, students are going to say, hey, wait a minute, I can have $300,000 in debt, or I can have $8,000 in debt and be making money while I'm doing it, And so, that's a really compelling, and some students are like, hey, I've never worked, I don't have any experience, whatever. Hey, I'll risk the 300,000. But if you've got that stark of a choice, it seems to me like, hey, do law schools have a future? Maybe that's the ultimate question. But if you could address either one of those 3 points, it would be interesting, certainly to me, sir.
Okay, I'll start. And I understand my 2 parts. One is about LSAT, and the other is about the future demise of all law schools. So first, there is a lot of truth still to the research around the predictive quality of an LSAT score. However, to be fair, and this is what the test makers say, that their test is not 100% reliable as that sole predictor. They believe that the test should be one factor among a larger analysis, holistic analysis of the student. And so we know that there are going to be false positives with that LSAT test and also false negatives. And we also see what we call in our field splitters, those students that have high, maybe standardized test scores and low GPAs, which we also know in our field are the most dangerous types of students to admit, because it indicates, so that goes back to like, how much do we want to value or give all of our scholarship money to a student who is able to do well on that test, but has other indicators that we know they need additional support, etc. So that LSAT score is supposed to predict success in the first year without intervention also. Okay, so also all of our schools have a lot of intervention. We have academic success programs and other support, and we want to, make that more robust as well. So the stronger predictor is your first year performance to your bar passage and other types of career trajectory. So there's ways to really get to that quality of graduate without the LSAT or in addition to the LSAT score. I don't think that the law school elimination seems reasonable because of that first year foundation component. And I do have to reemphasize this concept you mentioned about advancing the legal theory. So I always think about these two law professors that advance what we know in the law as the reasonable expectation of privacy connected to the Fourth Amendment. That was not in the Fourth Amendment jurisprudence until the court embraced two law professors' theory about this. And we really treasure the fact that the Fourth Amendment protects us not only in our homes, but in a phone booth and in our cars and other places. So I think eliminating not only the law faculty thinking about where the law should go, but in combination with students, new students, like as we teach them, we are trying to get them excited to take the law to its next logical conclusion. And I think about AI, other technologies, other things that you need to really have fresh eyes on at all times, because our laws are living, breathing, reflections of what we want to accomplish in our society.
Adding to Dean Lawson's answer would be these things, and thank you so much for your very good questions on LSAT utility, adjunct balance, and the alternative pathways and whether they foreclose the value of law school. I think Dean Lawson is absolutely right. There is a predictive quality to the LSAT. When I mentioned that we're very proud of bringing in the strongest class academically in 15 years at Seattle University School of Law, what I mean is with the highest average LSAT score and the highest undergraduate GPA. In 15 years combined. So there is a value. It is limited. It is most predictive of first year law school success, and there is some limited correlation between LSAT success and traditional bar exam success, not surprisingly, because the bar exam usually is a time limited closed book exam. So if you're very good at standardized testing, then you're likely going to do well on both of those instruments. But very limited utility, lots of false positives, false negatives too. So long as we keep it in its proper context, it remains a very valuable tool. I don't know that any of our schools in Washington State have eliminated the LSAT. We still very much use it as a very useful tool, but it has its limits. The best law schools have a good balance between adjunct professors and tenure line professors. I have served as an adjunct professor. I started my academic career as an adjunct professor at Georgetown University Law Center while I was an associate at Skadden Arps in Washington, D.C., and then became the general counsel of the Human Rights Campaign. The kind of work that I was doing with my students as an adjunct professor at Georgetown was quite different than the work that I ended up doing as a tenure line professor at American University. It has to do with presence, has to do with how much we are working with students outside of class, has to do with scholarship, has to do with engagement with our students in scholarly projects, and with a lot of other things that a full-time tenure line professor has the time to do that adds to the intellectual life of a law school. The role of an adjunct professor is very limited and is mostly instructional. Finally, your very good question about the potential threat to law schools of the alternative pathways. One of the reasons why I was very honored to serve as Justice Montoya Lewis's co-chair and the successor to Dean Rooksby as the co-chair of the Bar Licensure Reform Task Force was because we at Seattle University School of Law welcomed these alternative pathways, largely because they are very useful in providing options to our graduates to demonstrate competency. And I guarantee you that once the alternative pathways are implemented, there will still be significant demand for the traditional or next gen bar exam because it's quick. It's 1 day or 2 days, right? And there are some students that do well in standardized tests and similar tests that will want to get it over with, get the licensure proof, the demonstration of competency over with in a short period of time. For many of our other students who don't do particularly well with that kind of demonstration of competency, they will want to go through the alternative pathways, which are themselves difficult, rigorous tests of competency, to do just that. So I don't think that the alternative pathways are going to present threats to traditional law school education. To the contrary, they will reinforce the need to have great law schools in the state that will be able to provide the experiential pathway opportunity while for those students in law school through that pathway, and certainly to support students through the apprenticeship experiential pathway post-grad. So I will leave it there. I don't know if Dean Rooksby has anything to add.
I do. Thank you. Those are excellent comments from my colleagues, and I completely agree with them. I found your question very interesting, particularly the third question. I think this is a really interesting moment in education, in legal education and licensure across all 50 states. And one of the things that's lurking in the background is, what is the value of traditional educational experiences? And as we all know, law schools in particular have been pretty traditional in how they approach preparing people for the profession. And so do we continue to see value in that? There's obviously been changes in terms of experiential and other forms of simulated learning or externships, but what do we want? What do we feel is actually the best and right calibration for the amount of preparation? I will say schools like ours that have a faith-based mission, we're doing more than preparing people to pass the bar. We believe in educating the whole person. A lot of the work we do is foundational or formative with students outside the classroom, modeling professional behavior, helping them mature. And most of our students are coming right out of college. I think my colleagues can attest that the maturity level of these students, their needs coming out of COVID, all of these things. The traditional brick and mortar experience reaches many people in a way that is important and touches upon some of those concerns, which go beyond, preparing one for practice. So I think it's a wise question that you've asked. I don't know all the answers. I do know that other states are probably going to approach this differently. And one thing that I have worried about with respect to the alternative pathway is, do people have full information when they're pursuing that pathway about what that's going to mean in terms of reciprocity and practice in other states? Recognizing that story could change, but what does that story look like right now? And what are the likelihoods of that changing in one's, career if you look out 10, 15, 20 years down the road? So I'll stop there, but thanks for the question.
Thank you. Next, Governor Williams-Ruth.
Thank you, President Angela Bell. So first, I am a little shocked at what I feel has been a rather hostile exchange with our deans. The cost of law school has gone up as cost of all education. And if you really need to understand the cost of law schools, you need to understand universities and how they were treated as the cash cows for universities. And if you want to bring in the presidents of Gonzaga, University of Washington, and Seattle University, that's a conversation that we can have with them. But to put it all on the deans is, I felt awkward and uncomfortable. And I say, and I will fully disclose, I am a member of the Board of Regents at Seattle University and I'm a proud Seattle University graduate. I would have loved to not have $164,000 in student loan debt, but I didn't know anybody in the legal profession. Even though I mean, I knew a judge. My very first legal job was an undergrad. I was an intern for a judge in Pierce County, down the hall from former president and Judge Brian Tollison. No one offered to be a APR 6 mentor for me. And to think that they're just out there and that we can subvert our law schools. But I'm glad I didn't, because my entire life and profession and the last 25 years is owed in part to my time at Seattle University, which is why I've gone back to be part of. And Dean Lawson, thank you for talking about the $10,000 donation, because I spent the 50th anniversary of Seattle University working with their committee called the Legacy Society, getting people to think about the legacy contributions to give back to their schools. I am giving back, and 9 of my own friends are giving back. And I'm not going to be stopping. And I've continued to volunteer and support, because everything I am came from that. When I had difficulties and when I was fired for being gay, who did I go to? I went back to my law school. And when I went back then into the insurance defense world, and that's a whole other life, and I said, I'm ready for a change. 9.5 years ago, who did I go to? Annette Clark. And what did she do? She said, Brent, we're needing to change our PILF auction, so I can give you a small stipend to help just give you some money as you're reinventing your life. And now that auction is amazing. People are already putting it on their calendars a year in advance. And, so I would just ask anyone that wants to throw daggers at our deans to look and see, what are you doing for your school and how you're giving back. I am not ever going to give $45 million. Sorry, Dean. Sorry, Dean Verona. That's just not my world. But as we say at Seattle University, it's time, treasures, and talent. And, I want to talk about the balance of adjunct and tenure track professors. One of my adjunct professors was a King County Superior Court judge. And I know we're not supposed to say that we kept in, they became a mentor. And then when I was allowed to get married, they married my husband and I. And, and became a professional mentor. And in fact, my only undergraduate professor that I remember was a visiting professor from Purdue University named William McLaughlin, that came to the University of Washington for 2 quarters to teach constitutional law. So the balance of having that, I wouldn't have wanted to go to a law school where it was 100% tenure track. And again, I wouldn't have wanted to, because again, I loved having Annette Clark writing about academics, Dave Berner writing on PR. Eric Cippinelli and business entities and regulations. The people that have the published scholarship that each of these schools have is valuable. But then so is getting that practitioner that comes in and can give my last insurance defense firm, one of the named partners would come into the insurance law class to give real life examples to help supplement the academic case law and curriculum. So I just want to say thank you for your work in seeing the changing landscape. We are standing on quicksand. Academia is changing critically. I go back and I look at the first year curriculum and the life of a first year law student, and I don't see anything that resembles what I did. Sure, we could all remember exactly our caseload or our course load in 1L. 1 year full of property, contract, civil procedure. Criminal law for us was half a semester, or for 1 semester. Even just those basics have changed. And if you don't know this, I would encourage you, reach out to your school and say, what are 1L students doing? And learn how we are changing. And the academic rigors are changing to keep up with evolution. And AI is going to be another one So I have no questions for you, because I feel that, frankly, a lot of the questions have been insulting. And I don't think that there are ways to get to these conversations without it having been so antagonistic. And so and maybe it's because of the fact that I do split my time between the WSBA and Seattle University. And now that my time here on this board is coming to an end in 30 minutes, I'm going to be giving more time back to the Seattle University because I've got 2,500 hours I'm getting back. So I thank all three of you for the work you're doing, for the work you're going to be doing on the bar licensure, on getting those rules and regulations created, and for doing the best you can in a changing environment, realizing you've got administration to answer to, and and students that are demanding your attention, and all of the other things that go into making a successful program so you can bring the next generation of people that will be on this board and fight for whatever the legal profession is going to be 20 years from now.
Thank you, Governor Williams-Ruth. And I have the greatest of respect for you, Governor Williams-Ruth, but I have to respectfully disagree. I don't think people were being hostile. I think we were asking challenging questions. I want to acknowledge that I do appreciate all of you being here. I do appreciate that you know that the Bar Association and our law schools have long collaborated together, and that we will continue to do so. And sometimes that involves taking what might appear to be adverse positions for a minute, but there's no way in which we did not want to welcome you. And I hope that you didn't feel that it was a hostile exchange. In fact, I might say something else. It is the most engaged I've seen these folks in a long time, okay, after 4 months of being president. I've got 6 more people who want to talk to you. That never happens. So I'm sorry, Dean Lawson, did you want to say?
Well, I just wanted to comment on the necessity of engaged alumni, and that is so critical to our success as a school. So I thank you for your commitment to your alma mater, and I encourage all of the lawyers here to be engaged with the next generation of students. And I now invite one of our distinguished alum to join me in the welcoming of the class. And we've also added an alumni liaison to every student organization. So that mentorship relationship is critical for the next generation of lawyers. So I thank you for your commitment to service.
Thank you. And as I said, we have 6 more people who have questions, but I'm going to actually allow our executive director, Nevitt, to cut the line. She's asking a question that's particularly important to us in terms of our strategic priorities for this year. So I want to let her have her minute, and then I will go back to the list.
The joy of sitting next to the president. You get to like poke in there. Well, so a few months ago, the board met in the Spelum, and we had a dialogue with some leaders from our tribal communities in Washington. And there was a lot of feedback. It was a really rich discussion, but I think one of our biggest takeaways was a concern about just a general lack of understanding among Washington's legal practitioners about Indian law, tribal law, and they're feeling that it's such a problem because it comes up more than people think. And really the perspective they shared with us is that everyone should be able to issue spot or have some awareness of how tribal law might intersect with their practice. And so, at the bar, we've been thinking about the bar exam. We've been thinking about our CLEs. And one conclusion that we came to is that part of the challenge is that because we've done lots of writing, we've done lots of education around tribal law, but it seems that many practitioners don't opt into those programs because they're not aware that they need to know. And so one of the things, and the presenters also suggested that at law schools, this can be a challenge because likely you have a course that students could opt to take on tribal law, but probably many don't opt to take that. Law school's short. There's lots of other things to learn. So one of the suggestions, and I'm just genuinely curious to hear what might be some of the barriers, or could you imagine moving towards integrating tribal law throughout all of the courses, which is sort of what we've been talking about in terms of our educational programming?
I could certainly get us started. Thank you for that excellent question, Tara. We are very proud at Seattle University School of Law to have the Center for Indian Law and Policy, now helmed as faculty director by Najun Menka, who we hired from Berkeley Law. We're very excited that Bree Blackhorse, the assistant U.S. attorney focused on missing and murdered in Indigenous people cases, prosecutions, is our hybrid hub director in the Yakima Valley Hub. And going exactly to the challenge that you have put your finger on, sort of popularizing, proliferating these very important issues throughout the law school curriculum so that it isn't perceived as a niche subject that only those students who are interested in would take that particular seminar or that particular small course. What we are trying to do is to elevate the subject, a very important subject for reasons that you have pointed out, by doing things like having our first Luminaries in Law event from the Central Washington Hybrid Hub be an interview with Assistant U.S. Attorney Bree Blackhorse in an interview with me and with Professor Menka that will be shown to the entire student body, or that will be available to the entire student body. And we will be talking about those very issues. Why is Native American law, why is Indian law and policy so important? How does it manifest in international law? I mean, if you think about it, it is an international law subject, and in trade and in gaming and in contracts and in labor law and in farm worker rights and all the list of the courses that we have in our curriculum that go back to what Brent said, right, is an evolving curriculum. Everything has to do with Native American law and policy in some way. So we are going to be telegraphing that message to all of our students and faculty and prospective students too, across not just our Seattle campus, but all three hybrid hubs, to make those points salient.
Thank you. I'm curious if any of the other deans or Emily want to respond as well from the law clerk perspective and how tribal law awareness could be integrated there.
I would echo Dean Verona's comments. We have a Native American Law Center, and I think the challenge of making the curriculum is infused as we would like it to be is the expertise, and making sure, I think this is where adjuncts really do come in appropriately with a specialized expertise in certain areas. So we have an annual conference in September. Our Native American Law Center has this conference, and the experts from faculty, but also from agencies and from every walk of life that impacts federal Indian law and other parts of the expertise collaborate in that venue. So to get more lawyers and more students engaged at those conferences, I think would be a method to make sure they're having an awareness and maybe sparking a passion in that area of expertise.
Anyone else want to jump in?
If I may, I think this is an excellent point. And I took tribal law as part of my APR 6 clerk program purely because it was on the bar exam at the time and I was scared. I didn't know anything about it. I was like, oh crap, got to take the bar, I must learn tribal law. And I got to learn tribal law through the clerk program with the gentleman who was at the time counsel for Lummi Nation here in Whatcom County. So that was an amazing experience for me. But you're right. Most lawyers don't know a darn thing about tribal law, and we should probably do something about that. It should probably not be an optional elective, and I would love to see that integrated in the clerk program and other forms of legal education. That is a wonderful idea.
I agree. Unfortunately, I'm going to have to run. I have to go pick my daughter up from school, but thanks everyone. Good to be with you.
Thank you so much,
Thank
Dean.
you.
Really appreciate you. Next, we have Parliamentarian Stevens.
So first of all, I want to start, and I'm sorry that Dean Rooksby is gone, but I do want to start with thanking all of you deans and thanking you all especially across the board for your commitment to diversity. Dean Verona, I am technically a Seattle U grad. I'm a University of Puget Sound Law School grad. But I want to put a pin in that because just in terms of the history and how far we've come, when I entered the law school and after a thing called the booster program, before the first month was done, I was the only African American in the first year class, and there were only 4 of us in the entire law school. So when I think about the arc of what has happened, and in fact, and I forget now who the woman lawyer was and the context, but she somewhat younger than me, but she was talking about her experience at the University of Idaho and how she was one of maybe a handful of women law students. So again, how far we have come. And that's up against, by the way, kind of quiet conversations that suggest that by having a more diverse law school, your standards go down. So I appreciate it when you especially talk about the diversity of your school and also the quality of the students that you are still attracting. Now, having said that, in the conversations about the cost, I am just curious, and I'm a civil rights practitioner, not traditional practice, but I am just wondering, I'm thinking to myself, wow, way back then, if I was looking at these costs by myself, I would probably have said, oh, I'm not going to law school. I can't afford it, as a number of people probably say now. So I wonder, because you even mentioned a number of your colleagues at, I call it telephone book law firms, which pay a whole lot.
Telephone book.
Huh?
What's
What's a telephone book? Okay.
like a booster seat?
You're right. You're right. You're right.
Yeah.
That's good.
Yeah.
That's
Sorry,
good.
reached the top of the-
But I'm wondering how you recruit
Yes.
and what do you say
Yes.
to a number of students, or how you even identify them, that would be excellent candidates,
Mhm.
but
Yeah.
they're coming in poor,
Yes.
or they are poor and they're excellent candidates, but they're looking at what this is going to look like after 3 years
Exactly.
and how they're going to do the crushing debt.
Yes.
But Dean Lawson, if we're talking about public service, we're talking about public defense,
Mhm.
we're talking about the public areas that don't pay as much as you large law firms. I mean,
Yes.
I begin to wonder, how does this work?
Yes.
Because even if we're talking about the desert, even in the urban areas,
Mhm.
it's like I'm looking at these costs and I'm saying to myself, and I've actually said, a number of my colleagues who have graduated can't do the work I do
Mhm.
because they can't afford it, because they have crushing debt
Mhm.
to pay. So they don't even think about,
Mhm.
quote, public service. They may think about pro bono here and there.
Yeah.
How do you both work on the front end,
Yeah.
but also how do y'all work on the back end
Yes.
so that there are more lawyers who come out with a commitment, lifetime commitment to public service, what I call the people's law?
Well, I'd be delighted to get us started, but let me first say, Mr. Governor, that it is because of pioneers like you at the University of Puget Sound and at Seattle University years ago that we now are the most diverse law school, very proudly so, in the entire Pacific Northwest. It is very important for us to underscore, and this is why whenever my media colleagues, communications colleagues leave one of these things out, I always say, no, 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 no. We have to mention both, because diversity is coextensive with excellence, with rigor. And we take tremendous pride in the fact that we have been breaking enrollment records over the last few years. by bringing in the strongest class academically, which also happens to be the most diverse class. So they are not, the slander against diversity and DEI initiatives is that we sacrifice. No, that is not true. That is not true. And we certainly haven't done it that way at Seattle U Law. So thank you for being one of our pioneers and opening up doors and in very difficult ways, I'm sure, blazing that trail for so many students of color who have followed in your footsteps. So thank you very, very much. The other part of your question, though, is exactly why I said earlier this afternoon that there comes a danger with stating average costs of attendance, a bold number of overall tuition, because every student essentially pays a different amount. Every student has a financial aid package. One of the things that we do at Seattle U Law is look at every admittee individually and make sure that we are doing everything possible. This is why I myself have become a donor to the law school. At some level of financial sacrifice to myself, which I am honored to do, because I want to support my own students and also have the credibility with my donors that I am one of them, giving to our school in benefit of our students, because we need that kind of philanthropy. Just like Dean Lawson said, every dollar counts. So I think philanthropy is very important, fundraising very important, making sure that we make available to these students very customized scholarships, aid packages that allow them to come in without racking up enormous debt, and then having debt forgiveness programs and other programs post-graduation that address debt levels too. That's all very important. And then the other thing that I would say is that it's important for us also to develop mentoring programs, to strengthen existing mentoring programs so that students that come to us, I'm a first generation Hispanic student, immigrant student. So I understand those feelings of isolation and overwhelm that come with looking at those tuition levels. Even with a big scholarship, you fear that you're not going to be able to make ends meet, particularly if you want to go, as I did initially, and work for the federal government or work for a local prosecutor's office or defense counsel office. So you are absolutely right. Dean Lawson, do you have anything to add?
Yeah, I would just add that, as we celebrate 125 years of our law school, I want to share that our inaugural class included women and students of color. And I think that, that's a point of pride for me as the dean and for our school generally, that we were a leader in that space and continue to be. But, I'm not going to go into the dark side of that inaugural class that might not have been as openly received by the profession at that point in time in 1902. So that's something that from the bar perspective, we can make sure that we are supporting all students of all types once they graduate and pass the bar, which all of those graduates did. But not everyone was welcomed in the same way. So we had the first Black lawyer in the state of Washington, Japanese American lawyer, and women in that class. So as we all deans do this, share the excitement of our entering class. But when we peel back the various layers of diversity, oftentimes Native American law students and Black law students are still very underrepresented nationwide. And support for those students and those graduates is still very acute and needed, and new solutions. Just like we're trying to figure out the legal deserts, that's another solution that we need to have all hands on deck to fix, because the stats of Black lawyers, just as one example, in the last 10 years has not moved. Even though you have all of the debates about whatever, the results have not moved. So you can call it whatever terms we like to call it, but we want to focus on the results, and we want communities that need those lawyers to have those results and resources. I wanted to amplify the work that Law School Admissions Council has done at Heritage University, and I'll just tell an anecdotal story of two students that we both have. Dean Verone, I don't know if you know this part. So we go every year to Heritage University to help recruit prospective law students. And at orientation, a student came up to me and repeated back my speech to the class. And she said, "You told us that hard, challenges or pressure creates diamonds and pearls. So not to be afraid of pressure." And she said, "I was sitting there with my sister and we both love diamonds and pearls and we applied to your law school." So one is a full ride student at University of Washington, and another is a scholarship recipient at Seattle U. So making sure we have opportunities to provide awareness, information, access, support, and encouragement to all types of prospective students through the pipeline at HBCUs. I mean, California has legislative initiatives to fund graduates from HBCUs. That would be perfectly available under our laws if the legislature was so open to it. There are currently federal programs that support loan forgiveness for any lawyer who is pursuing a public interest job. So it remains to be seen if those resources will still be there, but that is another way to encourage people, even after they take on large amounts of debt, to still pursue public service and public interest.
Might I also
Yes.
say to her that we hosted last year one of our rapid response Supreme Court webinars one day after the SFFA decision came down. And there were over 2,000 participants, and it was covered by the media very positively. And Dana Matthew, our colleague who's the dean at George Washington Law School, kicked us off. And she's an expert in affirmative action and civil rights law. And she said that what the media were getting wrong, and I'm sharing this with you because we share this interest in the diversification of the legal profession and in continuing to do DEI work very thoughtfully. She's shared something that has stuck with me, and I have quoted about 100 times ever since. She said, what the media are getting wrong is this mischaracterization on their part of what the Supreme Court did around affirmative action programs, and characterizing what the Supreme Court did as ending affirmative action. And what Dana said, what Dean Matthews said was, that's not what they did. They are requiring us to engage in affirmative action and DEI work in a different way. And so then she went into how it is that we need to do this work in a different way, but getting to the same outcome. So that's very different than this mischaracterization of what the Supreme Court did as foreclosing, as canceling out, as making impossible continued affirmative action and DEI work. Not only must we do it, we have a moral imperative to do it and an urgency to do it because of these numbers that Dean Lawson I mean, it's incredible. Even in the Hispanic area, we are 20% of the population and fewer than 5% of law professors, practicing lawyers. And there are only 8 of us among 196 law school deans. That's ridiculous. I'm the first Hispanic Latinx law dean of any Pacific Northwest law school, despite the fact that the Mexican border was up to Oregon not that long ago, right? So this is very important work, and we have to continue it with redoubled efforts.
We have gone over a little bit of time, and I'm just wondering, we have a few more questions. I'm telling you, people are very engaged. Do you have a few more minutes? Because that would be great. Okay, wonderful. I'm going to ask our questioners, if you can, to keep it on the briefer side, not naming any names, of past or present speakers.
You are.
So the next person I will call on is Governor Fay.
Thank you for being here. My questioning earlier on the rack rate of your school is not to demonstrate the greed and avarice of your average law school dean. In fact, quite the opposite. Back when the mastodons roamed the earth, it was possible to go to a public law school,
Yes.
a public university like the University of Washington, where I went for a couple, and a public law school and work your way through paying the rack rate, which I did. And that is simply not possible.
Yeah.
Now, I have no doubt that the deans of these three law schools, and quite frankly, most every law school, are doing everything they can to extend the resources at their availability to allow students of different economic backgrounds to be able to become a lawyer. The difficulty, and this is where the rack rate comes in, let's say you're a kid who have fairly affluent parents. You are still struck with the cost of law school that puts you $200,000 in debt. Now you're in poverty, even though your parents are rich. And that is what we are asking our law school students to do. And my point there is that it's wrong. And now, why is that wrong? Well, at least for Dean Taylor, I can say this: back in the day, the state used to give the University of Washington a lot more money than it does now. And even though education is the paramount duty under the Washington State Constitution, golly, it doesn't seem to be anymore. And that is also true for the private law schools, because funding for you folks has equally been drying up for a variety of societal reasons. But I guess my point here is that big numbers, when light is shed on them, can show people out there, look, if you keep this up, you're not going to have any lawyers. Because in addition to getting on board to a very difficult, it's hard being a lawyer.
Sure.
But who wants to do that and sign up for a life of poverty too? And that's a problem that not the law schools can't fix.
Right.
You know, you're already doing the best you can, but we as a society have to do something to fix that.
Yeah.
And that's all I have to say.
Okay, thank you. Next, because I really do want to make sure everybody who wants to speak can speak. So I'm just going to tell you who the last people to speak will be Nam, then Jordan, then Emily. So, Nam.
I'll, for the purpose of time, I'll.
Okay, thank you. Governor Couch.
I'm just going to challenge you. I asked, what we can do to help, and I think your answer was a lot of like, we need money. Bringing the cost of law school down are hard. I'm just going to challenge you a little harder on here and say we have the ability to communicate with the ABA, which sets the regulations that put the barriers around you, and some of which are unnecessary in my own opinion. And we have the ability to push the legislature and the courts where we can when it comes to money, and we have the ability to be here for your graduates when they get out. Those are, I think, the three levers we have to pull. Doesn't have to be the next time we have this meeting. Whenever the ideas come to you, please come push us and tell us, hey, here's the letter going to the legislature, sign it. Here's the thing our graduate needs. Who can help them with this? Here's the rule that the ABA is considering right now. Join us in this. Go push them yourselves. We are here for you. Please come to us. As you can tell, this table cares a lot about this issue because it affects some of us personally. It affects all of us really in the people we're working with and the future of our profession. Come here, tell us, demand, let us know how we can help. Not when we ask you here, but when the ideas come to you, even if it's just signing on to a letter.
Here is one request right now. Please reach out to Jen Rosato Perea, the managing director of the ABA section on legal education and bar, and offer to partner with her in navigating the next year or so. Because I do believe that there will be some discussion nationally around the role of the ABA as an accreditor, and they will need very thoughtful partnership with state boards of state bar association boards of governors like this one, which is a very thoughtful one and very well respected across the country, to figure out what to do next and how to respond to challenges from the Department of Education and other areas.
Thank you.
Yes, absolutely.
And I can add that we will make sure that this Board of Governors has the timely information of all changes. So there's always a notice and comment period for any pending changes. And I will take it upon myself to make sure your group has that information as soon as it comes out.
Thank you, Dean. And Governor Arneson.
Thank you. I wrote mine down so I can stay on track and we can all get out of here. I appreciate you staying late. I appreciate all of your comments. I would just point out, I have two comments and one question. We all sat around this table yesterday and talked about costs rising. They're not going down. We raised our dues yesterday because costs are rising and we want to pay our staff. We want to provide services. You're in the same position. Law schools are not immune from what's going on in the rest of the economy, and there's a limit to what you can control. So I recognize that. It's in all of our best interest to have good quality law schools within our state. I think we can talk about that, and we can also talk about these huge numbers that it takes to actually pay for law school, and the severe immediate effect that has on folks when they graduate. I would just point out one thing. I'm in the loan forgiveness program, the federal loan forgiveness program. You have to make 120 payments, 10 years, at a rate that they gauge based on your family size and income. When I am finished, I will have paid about 150% of the amount that I took out. And part of that is because interest rates for graduate school loans are about 3 times, at least they were when I took out mine, about 3 times the interest rate as undergrad. I say all that to say, if there is some kind of solution where there could be a tuition deferral at a 0 or low interest rate, wherein a person could pay until they reach what they would have otherwise paid and then stop, that might be something that would take the burden off of somebody, because I'm still feeling it pretty severely. So that's one comment. Second one is that folks talked about the LSATs and standardized testing and that correlating to success in law school. And that's clearly important. We want students we don't set people up for failure. We want students who will succeed. I just want to also point out something that I think you're aware of already, that the performance on the LSAT is also correlated with family wealth, with whether you grew up in a Western culture, with whether you grew up with English-speaking parents, all of those things. And so I say that to encourage you to continue, sounds like you already are, but to continue to try to focus your financial aid goals more on the students with economic need. Just putting that out there. Lastly, I am glad to hear you talk about accommodating students with disabilities and having that be a more common thing that's coming up. I would encourage you to also be accommodating to non-traditional students, and I'm speaking specifically about parents. And I say that from personal experience. I have particular concern for female students who in heterosexual relationships still tend to bear more of the burden of raising children. And the time people go to law school is often the time that they start families or grow their families. When I was at the University of Washington, the only reason that I am sitting in this chair right now, the only reason that I am a lawyer is because they have that room. Do they still have the room, the family room where you can go in? They have a room in the law school with closed circuit TVs where you can watch, at least they used to be this way, you could watch your classes from this room. It's the parents' room. It had a little kitchenette, fridge, 2 private rooms where you could nurse or pump milk. There were little cribs in there. There was toys, because there were a number of people who had children during law school or had young children. Had that not been there, I would not be here. So I encourage you to really accommodate parents, and especially because of the disproportionate effect that has on women over the course of their life and their earning potential. My question is, are you doing anything for parents in law school?
I will say we are not doing enough. And I love this idea that I'm going to take back to my Seattle University School of Law community. We are doing a lot. And what I've heard from a number of our students who are parents and a lot of them single mothers in the FlexGD program particularly, telling us that if it were not for the Flex GD program, they would not be able to attend law school, and that they really appreciate the flexibility that it brings. But we can do more, and so I thank you for that reminder.
I would just add that our emphasis is on holistic admissions and also holistic support and 360, as I mentioned, wraparound support of all students. And so as needs also change of our student body, which is over 60% female now, we are also changing our resources and support. So thank you for that reminder and additional perspective. Thank you.
Well, I really want to thank Chair Rose, Dean Lawson, and Dean Verona. It's always a pleasure to have your yearly visits, but I hope that you take what Governor Couch said to heart, which is that we're here and our door is open, and I consider us all to be a team working together for the betterment of the legal profession. So please know that you can reach out to any one of us at any time, and we would be happy to continue dialogue on many of the topics that we talked about today. So,
And you can challenge us and ask us hard questions.
exactly. Oh, yes, please do. Feel free to. But thank you. And I want to ask for a round of applause.
Thank you for having me.
Yes, absolutely. And actually, board members, I think we're going to take a 5-minute break. We've got meeting feedback after, but